Welcome to the Commercial Know-How podcast, where mortgage brokers learn how to successfully launch, manage and grow a commercial finance business. I'm your host, Belinda Gibson. Join me as I draw on more than 25 years of property finance expertise to show you how to diversify beyond residential and build a growing business for all seasons. Don't forget to hit subscribe and visit commercialknowhow.com.au to download my free ebook to help you get started in commercial finance. Now, sit back and enjoy the episode. In today's episode, we are going to be discussing the 7 things that you need to consider when reading a commercial contract of sale. Today's podcast will highlight those 7 important considerations you need to keep in mind during the process. Now, the first one is GST. So when you're reading the contract, depending on what state your client is buying in, you need to understand the GST implications on the contract. Now, in each state, each contract of sale looks a little bit different, but GST is definitely highlighted. You need to read it and understand if GST applies to the contract or not. Determine whether the stated price is inclusive or excluding GST, and if your client is eligible to claim the GST back. Now, 2 tips here. If there is a lease attached to the contract of sale, generally GST will not apply, so that's a win. Second of all, if the vendor is not registered for GST, GST may not apply, but it's really important that you read it and interpret it. Ask the question to your client. If GST does apply, you need to factor it into your funding table. So keep this in mind. If your client is buying a property for $1 million, the GST implication can be $100,000. It's 10% of the contract price, and those funds need to be available on the settlement day. Number 2 is the purchaser. So review the contract to identify the parties involved. Who's the vendor? Who's the purchaser? Who are the conveyancers and solicitors acting on both sides? Pay attention to the purchaser's details, such as the purchaser's name that they've put down. Now, is this a proprietary limited entity? Is it a family trust, or is it in an individual name? It may also be an and/or nominee. So quite common is to see a purchaser establish what we call an SPV, or a special purpose vehicle, where they are creating a new company structure. It may or may not have a trust attached, and that will be your borrowing entity. Now, if there is a and/or nominee on the contract, once they have established who the borrowing entity is, you will need to obtain a nomination form. Now, as a good tip or a best practice here, it's always a good idea to email your client's conveyancer or solicitor as an introduction to say that you are looking after the finance for X property address, and that you've got any questions that they can come back to you, or you may have some questions for the solicitor or conveyancer to ensure you've got the borrowing entity correct. Another best practice tip here is to also check if your client has obtained any accounting advice around the structure in which they are buying. Now, this is also a great best practice to follow if your client is new to buying commercial property. Number 3 is the finance clause. Now, you will be very familiar with finance clauses from being a residential broker. It's very similar in the commercial space. However, a 5-day finance clause or a 14-day finance clause simply will not cut the mustard if you are requiring a commercial evaluation. So remember, we reach unconditional once we have the evaluation back. Now, in the commercial space, evaluations can quite often take 14 to 21 days, depending on the actual property itself, and you need to factor this into the finance clause. So if it is 21 days, that might be okay, but generally try and work towards 28 days on the finance clause, and settlement date at least a minimum of 60 days. It would be very difficult to settle on 30 days if you are needing a full valuation. So here, understand the terms, including the timeframes to secure financing, the loan amount that your client will require, and the consequences if finance does fall through. And number 4 is the settlement date. So take note of this. Now, some contracts will have the actual date. Others will have a certain amount of days after signing of the contract. Work out what day that is, ensure it falls on a weekday, and make sure there is ample time to go through the finance process, have your approval issue, and the bank be ready for settlement. It's crucial to be aware of the agreed upon date on which the settlement is due and any penalties or conditions that are tied to meeting this deadline. Now, number 5 is the number of titles available. It may very well only be one, but it may be a number. So understand if multiple titles are involved. This may impact things like a bare trust. So if you are doing self-managed super fund lending, quite often multiple bare trusts are required if there are multiple titles, unless it is deemed to be a single acquirable asset. But otherwise, you're just making sure that what is on the contract matches what is going to be prepared on the mortgage. Number 6 is to review for leases. So pay attention to any existing leases that may apply to the property. Review the contract carefully to understand the terms of the lease, the duration, how long is left to run, and if any options apply. And outline the obligations outlined in the lease, things like outgoing. So building insurance, rates and water are very common because it does mean that your client is receiving 100% of that rental income, less any management fees, of course. A hot tip here is just to review the valid lease on a commercial contract, because it can negate the need for GST to apply, which we spoke about earlier in the podcast. Number 7 is miscellaneous clauses. So your contract may be subject to some special conditions. So thoroughly read and understand what is in the actual contract and clauses that may apply. We have had one recently where it was highlighted in the special conditions that there may be soil contamination on the site. The vendor had prepared earlier a quote from a specialist business who could do some soil testing on the site. He had obtained a quote to prepare those services. Our client did still proceed with the purchase, but a condition from the lender was that we needed a clean soil test or within particular levels of soil contamination. Now, thankfully for our client, the soil was clean and we were able to proceed to settlement. Now, if it was not the case, our client would have had to investigate having the soil refurbished and new testing completed to bring the contamination levels down at an acceptable level to the bank. But thankfully, we did not have to go down that path. It was a clean site, but the vendor had highlighted that from the get-go. Another special condition that we did see in a New South Wales purchase last year was in the Section 32. The council had permitted uses on the site. They had some stipulations that the property could be not used for any industrial purposes. It was on the fringe of the CBD, right on the edge of the main street, and they in particular wanted office accommodation or retail, and they had some stipulations around who could operate a business from those premises. They didn't want any type of community services, hospitalities or function centres, and definitely not anything industrial. In this scenario, our client had flagged with us from the get-go, but they have turned it into some service offices, which was much needed in the town. So in conclusion, reading a commercial contract of sale carefully is vital to protect your interests and, more importantly, your client's interests. Ensure that they seek legal advice to have the contract of sale explained to them before they sign and what their obligations are. Now, if they are uncertain about any clauses or terms, or you as the broker are uncertain about any clauses of terms, please refer back to your client who can address these items with their conveyancer or solicitor. Remember, it is also essential to review the GST implications and understand the purchaser's details. Consider the finance clause and the settlement date to make sure you have ample time and know the number of titles applicable. Carefully review any leases and special conditions that may apply as well. And if you follow these tips, you will be better equipped to navigate the commercial contracts of sale effectively and make informed choices to help your client on their financial journey. Please note that today's podcast does serve as a general guide, and it is highly recommended to consult with a legal professional when discussing contract law and contracts of sale. It is specific to your client's situation. Thank you for listening to Commercial Know-How podcast today, and don't forget to visit commercialknowhow.com.au, where you can download my free ebook to help you get started in commercial finance and how to reach out to me. And make sure you subscribe on your favourite podcast player so you don't miss an episode, and we will hear from you again soon. Thanks for listening to the Commercial Know-How podcast. Don't forget to visit commercialknowhow.com.au, where you can get in touch with me or download my free ebook to help you get started in the commercial lending space. If you enjoy the show, please hit subscribe so you don't miss an episode. See you soon.